Hello. Welcome back to Module 4, the American Republic in Practice. In the last video, we covered the U.S. Constitution and how certain articles grant the federal government its powers. Today, we'll discuss the Bill of Rights and briefly examine how each amendment secures your natural rights and personal freedoms. The Bill of Rights is a clear indication of the Anti-Federalists' position and influence, which we touched on in the last module. Returning to the subject of negative rights for a minute, the First Amendment states that government has no rightful authority over free speech, religion, and assembly and is blocked from infringing upon them. As the Constitution says, Congress shall make no law. Your right to free speech exists because that is a natural right. Over time, though, the courts have developed the principle that free speech is subject to reasonable time, manner, and place regulations that maintain public order and safety, and the protection of the rights of others. The regulations must be content neutral and not driven by an effort to restrict the content of speech. These can take the form of noise ordinances, parade permit requirements, or limiting demonstrations to public forums such as sidewalks, streets, and parks. Certain other forms of speech do not enjoy First Amendment protections, including fraud, speech that violates intellectual property, defamation and libel, threats of violence, and false statements of fact. These are forms of speech that cause direct harm to others and violate their individual rights. Freedom of speech is the price we as a free people pay for living in a constitutional republic, even if that speech is vile or objectionable. Supreme Court Justice Oliver Wendell Holmes stated, "When men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out." That, at any rate, is the theory of our Constitution. It is an experiment, as all life is an experiment. This popularized the notion of the marketplace of ideas. Holmes' fellow justice, Louis Brandeis, later argued that, if there be time to expose through discussion, the falsehoods and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. This has become known as the counterspeech doctrine. The Second Amendment is a single sentence yet has been the subject of ongoing, sometimes vigorous, debate for decades. The central argument largely rests on whether the amendment protects the right of individuals to keep and bear arms, or this is a right that can only be exercised by militia organizations such as the National Guard. The founders and framers had seen firsthand that European monarchies used soldiers to oppress the citizenry. English history suggested that the remedy to this problem was to have a militia of ordinary citizens who supplied their own firearms and equipment. The debate between the Federalist and Anti-Federalist factions in the Constitutional Convention revolved around whether federal assumption of the national defense in the form of a standing peacetime army would reduce the state's ability to resist federal usurpation. Implicit in this debate were two mutual expectations. The Constitution gives the federal government near complete authority over the armed forces, and the federal government does not have the authority to disarm the citizenry. The argument between the two factions was whether an armed population could reasonably serve as a check against federal oppression. Since 2008, the Supreme Court has endorsed that the amendment guarantees the right of citizens to possess firearms. The government cannot ban or significantly limit this right, although there can be laws that regulate certain weapons. For example, the National Firearms Act of 1934 introduced a tax and registration system for machine guns, short-barreled shotguns, and sound suppressors. Require permits. Restrict where a gun can be carried, such as schools, government buildings, and other sensitive areas. Restrict on the basis of age. Individuals must be 18 years old to possess long guns and 21 years of age to own handguns. And limit who exactly can own firearms. For instance, convicted felons, the mentally ill, and those under domestic violence restraining orders are prohibited from possessing firearms, although there have been legal challenges from nonviolent offenders. The Third Amendment prevents the federal government from quartering, or housing, soldiers in a person's home without consent for any reason during peacetime. This had been a real issue in England before the time of the American founding. Unlike the Second Amendment, the Third Amendment has caused little controversy over the centuries. The Supreme Court has never heard a case based solely on the Third Amendment because it is so clear-cut. However, there are two aspects in the language that should be mentioned. During peacetime, the government cannot force a person to quarter troops in their home without their consent. However, in times of war, Congress could pass a law that requires homeowners to quarter troops. Nevertheless, in a further separation of powers, the military, an executive branch agency, must follow the law laid out by Congress, the legislative branch. Additionally, the Third Amendment reinforces several important ideas. For example, it protects citizens from government intrusion into their homes, and protects the privacy rights of citizens within their homes. The Fourth Amendment limits the power of law enforcement officers to conduct unreasonable searches and seizures of people, their property, and their homes. Naturally, the framers could not foresee the internet, drones, or other modern technologies. They were concerned with general warrants and writs of assistance used by local night watches. General warrants had been used by the Crown to search people and places without any reason to believe an offense had been committed, while writs of assistance were similarly applied when searching for allegedly untaxed goods. Before the establishment of professional police departments, night watches were local citizens who patrolled the streets of their towns. To answer these types of abuses, the Fourth Amendment directs that the government must seek the approval of a judge before executing a search warrant. In order to justify the search and seizure, the court must be shown probable cause, which are the reasons one might reasonably suspect criminal activity. There are several instances when search warrants are not obtained, searching automobiles, people in the street, or in exigent circumstances. The most common practice regarding the Fourth Amendment is during criminal investigations. Evidence seized by law enforcement without the benefit of a warrant can be excluded in court, as can any additional evidence that was discovered as a result of the illegal search. In this technological age, the notion of searches and seizures and the Fourth Amendment has become more complex. Reflect on closed-circuit TV cameras in public areas, flying drones in residential neighborhoods, and the bulk collection of digital information shared with internet providers or online vendors. The Fifth Amendment protects citizens from unjust treatment by the federal government, especially if they are accused of a crime and face punishment. These protections include the right to indictment by grand jury, which determines whether there is sufficient evidence to move the case to trial. The right to a fair trial. The right to not be tried 2 or more times for the same offense. This is called double jeopardy. The right to not provide testimony or evidence that could be used against yourself. This is commonly known as self-incrimination. The right to due process of law, which refers to the impartial procedures and equal treatment that must be applied before depriving someone of their liberty, property, or life. The right to not have your property seized by the federal or state government and used for public purposes without fair compensation. This is eminent domain. The Sixth Amendment builds on the Fifth by guaranteeing the right to be informed of the nature and cause of criminal charges. The right to a speedy and public trial. This is an answer to the issue of justice delayed is justice denied, as well as demonstrating openness and transparency in the trial court system. The right to assistance of counsel, which allows defendants to rely on trained attorneys to navigate the complex legal system. The right to be judged by a jury of your peers, which provides an awareness of civic engagement and participation in the judicial process. Additionally, juries provide a check on any arbitrary actions performed by the judiciary. The right to confront and compel witnesses. This is known as the Confrontation Clause, and allows defendants to challenge and cross-examine their accusers. Subsequent court decisions have wrestled with the admissibility of hearsay evidence and witness statements when cross-examination was not possible. The Seventh Amendment guarantees the right to trial by jury in civil matters. Please take note that this refers to civil cases in federal courts rather than criminal ones. Civil trials handle disputes between individuals and organizations, and the juries will determine damages. Although, many judges try to encourage the litigants to reach a settlement, so as to avoid the expense and delay of a trial. The United States is one of the few countries in the world that require civil jury trials. Like many constitutional points, this unique choice is derived from the framers' experience under British rule when colonial juries had helped in the struggle for independence. The Eighth Amendment continues the legal protections guaranteed to citizens by prohibiting the government from imposing harsh penalties on defendants. The first protection mentioned is the prohibition of bail that is so extreme that no one could possibly pay it and be released from pretrial confinement. Bail is a monetary amount one pays the court to guarantee they will not flee the jurisdiction, but instead stay and participate in their defense. The second is the Cruel and Unusual Punishments Clause, which was meant at the time to forbid brutal punishments such as the rack or thumbscrews. Since then, there has been debate over what constitutes cruel and unusual punishment. Some of the considerations are, what standards should be used? The standards of 1791? The standards of today? The Supreme Court has interpreted the term to encompass inhumane punishments, demeaning punishments, and punishments disproportionate to the crime, such as flogging for a speeding ticket. The original meaning and legal effect of the Ninth Amendment is a subject with intense scholarly interest. The courts have been inclined to interpret the Ninth Amendment as dealing with rights not specifically mentioned in the Constitution. These are called unenumerated rights. Basically, the amendment seems to empower the courts to uphold the notion that citizens have rights beyond those explicitly named in the Constitution. For example, the right to privacy and parental rights have both been recognized to be unenumerated. Using this argument, the Ninth Amendment connects to the 10th and 14th Amendments to safeguard individual rights. Yet, other legal opinions caution against the recognition of unenumerated rights, which might cause the courts to overstep their limits and infringe on the state's prerogatives. As a companion to the Ninth Amendment, the 10th Amendment raises the idea of reserved powers. These are powers not specifically delegated to the federal government. In other words, if the Constitution does not assign a definite power to the federal government, it is instead set aside for the states or to the people. This is different than the exclusive and concurrent powers we have already discussed. Powers reserved to the states include supervising public schools, overseeing elections, and establishing local governments. The 10th Amendment emphasizes that the addition of a Bill of Rights to the Constitution does not alter the essential character of the national government. The federal government is one of limited and enumerated powers. This power dynamic means that the first consideration involving a use of federal power is whether the action in question exceeds the federal government's enumerated powers. Next time? In the next video, we will dig deeper into each of the three branches of government and discuss how the Constitution grants power to them. Then, we'll look at how the branches exercise those powers while fulfilling their constitutional roles. Until then, thank you for your time. If you want to learn more about the subjects we have discussed, here are the sources used for this section.